And so I'm concerned about those things, but I think it's important that we are having this conversation and have had this conversation for the reasons, Mr. Chair, that you have mentioned, given the prevalence and impact that DUI and impairment convictions have on our system as a whole. We've clearly got to get our hands around some of these things. I just want to make sure that we do it in a extremely conscientious way because the mistake potential is high and the ability to undo what we recommend from a committee like this I don't think it's possible. If we go down that road, we have gone down that road.
Uh, I agree with everything that both of you said. I think Judge Espinosa's proposal is kind of a clever one, is to go sort of part way down this idea and try to isolate the 0.5 to 0.08 and have that as a mandatory diversion or some what's the irony here is that what creates the public safety benefit, and this is half of all, it's not just the number of convictions, half of all road fatalities. This is a lot of, this is major public safety issue. Is that the news of changing from 0.08 to 0.05, that's what creates the public safety benefit, because people then stop drinking. It's like the LA Times story about the legislator doing this is what creates the benefit. It's not the field sobriety or the diversion or whatnot. And I think, again, I hear your point about whether or not Utah is emblematic, but if we have fewer DUI arrests, it's narrowing, right? Because fewer people arrested, that will disproportionately benefit those who are disproportionately arrested, which are Black and brown people. So if we can reduce the overall number of arrests, that has racially, disparate racial benefit. I think it's very hard to tell. So anyway, I think that Rick and Tom, you get the concerns. We are all very concerned about net widening for all sorts of reasons, especially the racial impact. Whether Utah is a good model or not, there's not a lot of states who've done this. And I take, Assemblyman Bryan's point, and we're California, we're huge, and we're nation. If we were to recommend this, and this were to become law, it would spread quickly, I think, nationally.
It would be 1 in 8 Americans who are under this law.
Oh, I think but I was trying to say it would be even more, because I think it would spread very quickly to other states. At the same time, when somebody said to me, 4 drinks, I'm not getting behind like there's just that piece. And if this is an opportunity if it is a genuine opportunity to save lives, I'd like to sort of know the data better. We've always been, tried to prioritize data. And so let's dig into that as much as possible. On both scores, what is the public safety benefit, and how can we analyze the racial impact as best as possible? Whether we need to get Steve back in this, look deeper into California data, or those are kind of and then I think, to Judge Espinosa's point, is there's some kind of clever compromise where we can at least buffer against the worst outcomes. Whereas, meaning, is there a way to address the difference between the folks that fall into that 0.05, 0.08 area? Tom, were you going to say something?
No, I think we were having similar thoughts of going. I think all 3 panelists on the research side are very eager to engage in this issue. So I think going back to them and essentially continuing that conversation is something we can do, and we can try to look at the RIPA data a little bit closer and see what insights that can give. Also, before we got off this, I wanted to mention, it didn't come up much today in the discussion, but I think one of the other aspects of the diversion piece we had was that it could be sort of counted as a prior conviction if you had a subsequent DUI, because I think we saw that most people, vast majority of people, do not have that, but those who do, it's irrelevant, I think, to how that case would be decided. So I don't know if anybody had any thoughts or objections to that. I just wanted to foreground that.
That makes sense to me. Another,
I'm not sure what Tom's point was exactly.
The point here is that, right, there's people with multiple DUIs get ratcheted up in the system. If you go through a diversion program and your conviction is dismissed, right, it could still count as a prior for your next DUI.
Well, we could recommend that it not.
Right, but I think that the recommendation is that it does, even though dismissed, that it would still count as a subsequent DUI. I think that's a level of detail before we even.
Right. For example, if you did diversion and then 2 weeks later you get arrested for DUI again, it doesn't necessarily make sense. You then do first time DUI diversion again immediately if it's sort of we just saw it didn't work for you, and that's why I think the next idea about what do we do about people who have more than one DUI, those ideas start to kick in a little bit more.
The other, getting back to the 0.05, 0.08, I was curious about if there's anybody in Utah who could speak to their success or not, or applicability to California or not. I mean, maybe not, but it'd be interesting.
Yeah, we'll check that. I know Rick had a lot of conversations with NHTSA, which is the Federal Transportation Board. They did this study that everyone's citing about the effects there. So we were hoping to have them here today, but it wasn't possible. So we'll continue to kick the tires on all this very deeply.
And as some people have said, the diversion piece, which I like to be paired with, doesn't necessarily need to be paired with, right? We could recommend a diversion for first-time offenders, regardless of whether it should.
Right. Yeah.
And the data does seem to support the idea that arrest is sufficient. I'm a little concerned about sending everybody to these schools and these programs and these classes of which there is appears to be no oversight, except for, is there enough width in the hallways for wheelchairs to get down? But nobody cares if these actually do anything.
Well, we're currently sending people to those very programs.
Right.
I mean, I recognize and have been since I was a municipal court judge, a few decades ago. So, and the thing about those programs is they're not like the community-based organizations that Assemblyman Bryan and are used to talking about. These are for profit businesses. These are businesses that are run for profit, which is why very few people are getting the $5 option. So it's a different world.
So you're saying, I'm sorry,
I didn't make my point very clear. I'm just saying these people are going to these programs now anyways. We have no way of measuring their outcomes or whether they're actually changing people's behavior. And until we do, I think we're sort of stuck with these programs. And so why not incorporate them in a mandatory diversion program for a certain class of first offenders?
well, we could recommend somebody evaluate them.
Well, that too. Yeah.
I mean, I don't know if we want it. I mean, I was talking about this with Rick and Tom offline and saying, it's in some ways part of the what word am I looking for?
Deterrence.
The deterrence, right? People, whether or not they're effective, they may deter people from drinking and driving, meaning like, I'm gonna get my license suspended, I'm gonna have to go through this class, it's gonna be a huge pain in the ass.
Right.
Whether or not the class does anything other than be a pain in the ass, I think is the question.
Right.
I
Hard to
would love
say.
to hear Rick, were you ever to touch bases with the classes? What do they say? Do they have any evidence that they
I
work?
haven't spoken to any specific classes, but just to your other point, if the committee were to recommend mandatory diversion for first-time offenses, it could specify that and diversion include an IID and a license suspension and not the classes. I mean, but to Judge Espinoza's point, they are kind of a current, like prevalent aspect of our current system. So there may be reason just to kind of stay in that lane, or you could say, look, we're gonna for the diversion piece, we're gonna say do the, you could limit it and say we're not gonna do that.
We heard a little bit of conversation about what is it, IID with the breathalyzer?
Yeah.
Seems quite effective, at least for the period while you're doing it. Is this something that we want to meddle with? It could be part of diversion or not.
I don't think it's I look at these folks in terms of their level of acuity, and somebody who's picking up their first DUI and has a low blood alcohol level probably doesn't need an interlock device. We've gotten their attention. Their attention has been gotten. They're not going to drink and drive again. A vast majority of them. I mean, I told all of my kids, any one of you could get one drunk driving, and I get that. But when you get the second one, it's an indication that, there's something more going on here. But with these first time offenders, low BAs, they have a sort of low acuity, in my opinion. And I don't like the fact that the cost, or at least part of the cost of these devices, is pushed onto the consumer because it sounds expensive.
Yeah, the
Mhm.
cost issue, I think that has to absolutely be addressed if we're gonna have mandatory divert, I mean, that
If
just
it's,
seems.
yeah, if it's going to include the interlock, you know, I just I
So
think that's
what would, in your mind, then what would diversion entail?
I don't know. I used to do interesting things with people that I was diverting outside of normal diversion, like requiring them to attend a certain number of Alcoholics Anonymous meetings, come back with proof that they've done that. Now, that again isn't the 12-step program isn't a magic bullet for everyone that gets a deuce. In fact, I don't remember what the numbers are, but the percentage of people that tried the 12-step process and are successful is pretty low. But we something like that, some sort of um, I don't know, go to the morgue. I mean, we used to do that. We used to send people to the morgue to hang out and see the bodies coming in from these accidents. I mean,
As a statutory reality, I mean, like, I mean, I think I'm okay continuing saying the class
mhm.
and its interlock. I mean, I don't know,
I think as a general rule of thumb, I'm always hesitant when we build up an industry off of decisions we've made regarding the parameters of the criminal legal system and supervision. There was actually was a bill 2 years ago that came before the Assembly Public Safety Committee that I believe would have made current DUIs a misdemeanor and required the interlocks in everybody's car on some sort of a sliding scale. I was sitting on public safety when that was heard, so maybe something for the committee to also go back and kind of um, discuss with the previous chair and others who kind of saw that issue. I think there's a utility for these devices that I'm not saying they shouldn't exist or that we shouldn't have them, but to make a recommendation that would lead toward requiring them for a huge number of cases. And we know, even the low end of that number, that's the whole point of this conversation, is that there is a market for these interlock devices. I don't know if that's a burden that the public should carry fiscally or that people should carry fiscally when we statutorily require it to be a part of this, if there are other alternatives that are more cost effective for both taxpayers and individuals, like Judge Espinoza has mentioned. I don't know what the right basket of those are. I don't know what cases you would then, want to go a step further and have an interlock device, but I think that that whole range of opportunities is something we've got to be pretty thoughtful about.
so again, I'm with you, I think I like the, what's the right basket, question. But the idea here is that we want to encourage diversion, so that's less incarceration and, right? But diversion to what, I think, is the basket. And that we need to kind of figure out how we legislatively keep that flexible. Or diversion, what is the basket that we're diverting to? I think that's kind of the question. Um, to staff. Um, so, and we were talking, and I think the idea, the general gist of the staff recommendation is that we're targeting first-time offenders with low or medium BACs and no kids and no injuries. That seems like a right area. It's a large number of people and the lowest hanging fruit. Everybody agree with that?
Yes.
Yeah. Additional thoughts on the diversion piece? Okay, the next recommendation, I believe, which is kind of related to diversion, is to increase these collaborative courts for the more serious offenses, whether that's repeat offenders or people who have injured people or whatnot. You heard what I said. I feel like a broken record on these collaborative courts. They work. I like everybody who does them, likes them, but they're infinitesimal in terms of their scale. I don't know if you all have, I thought the idea of looking at 1170.9, which is the Veterans Court, might help. Anyway, thoughts?
Well, 1179 has been the law for some time and almost nobody uses it.
But this is for the veterans.
For the veterans, yeah.
Yeah.
You can, in essence, create your own, and I did in my early disposition court. I said I have the second largest veterans court in LA County because I had a number of veterans on probation to me who had been rejected by the veterans court, right? I would send them downtown and the DA would object and they'd come back to me and I'd use 1170.9 just to put them on probation and make them get treatment from the VA, which is what the veterans court is supposed to do. So I guess my point is we can look at that, but it's not going to be enough just to give judges an option. I think if we want to be really impactful in diverting these cases or getting treatment for these folks, there has to be some you shall language somewhere for the whatever cases we decide.
I think unlike two other collaborative courts where we're thinking about drugs, which is like a huge population of people who are coming in and out of courts for drugs, we're talking about collaborative courts for second or more repeat DUI offenders. That population of people is actually relatively small, whereas it's like around 70,000 convictions for first timers. The second timers are, I think, around 5,000 statewide. So it's not a huge, I wonder, our legislative members and their staffs would know more about like what the fiscal would be if you were to require it. But I do think that it is unlike other collaborative courts where requiring counties to do it would come with a huge price tag. Perhaps that's not as much the case with repeat DUI just because it's a smaller group of folks.
Somebody remember, Brian, do you have a thought on this? I think this is, like I said, I think this is a tricky nut to crack, because you shall do what? Establish some sort of kumbaya between everybody in the system. I mean, it's hard. You could say, must suspend the sentence, for third time offenders or whatever. And if you complete the Department of Health shall, approve at least X number of, treatment slots available per year. If you complete that program under the supervision of the court, you shall get dismissed. I mean, I guess that's where you get the shall stuff, but it's hard for me to envision. Judge,
I apologize, Mike.
you have to go.
I have to go, and I don't remember leaving one of these meetings early in the
No,
few
you
years.
get a hall pass.
And it's only because I have another meeting. So I'd rather you not take a break until 3:00. I think maybe if you want to catch me up on the conversation or have Tom catch me up, I think that's fine.
Yeah, agreed. I think that we, based on what we've had so far with the Assemblyman Bryan, with your permission, I'm going to move on to, I think public comment is all we have next. Is that right, Tom?
Correct.
Thank you, guys. I'm going to
I
bail.
will touch bases with you, Judge Espinoza, Judge, Assemblymember Bryan. Maybe you could also touch base. Rick will also reach back out to you to make sure that we cover anything that you want. And of course, Senator Skinner and so
Thank you.
have a good afternoon.
Okay, bye-bye.
All right. So, with that abbreviated conversation, I think we've had a great talk today and another awesome slew of witnesses. Rick, again, nice job. Like I said at the very top, was of course aware of DUI being common. I hadn't been quite as aware of just how common it is. Like I said, it might be the most common crime committed in California. And it goes all the way from, misdemeanor offenses to people dying. And I think that there's and it's really confusing, honestly. The statutes framework, and the science. And I think makes it a ripe area for us to weigh in. And I think that we can both improve, again, my mantra of improving public safety and reducing the incarceration at the same time. So we've reached the time for public comment. With those listening on Zoom, to get in line to comment, please select the raise hand function on Zoom. Let me pause here for a second. We often get a lot of comments about issues that are not super germane to what we've discussed today. That's important. We will hear you, of course, but really it'd be most helpful to hear from comments on what we've discussed today, which is DUI. If you are calling in, please hit *9. Note that this meeting is being recorded, and if you make a public comment, your name or phone number will be displayed. If you're watching this meeting or at the physical location, Rick, is there anybody there?
Let me check. No.
All right. So anyway, we'll take a minute now to see how many people want to comment, and based on that, I'll see how long each person has to comment. Please note that the committee also accepts and welcomes public comment in writing, and that comment can be emailed to committee staff whose emails are on the committee webpage. So please raise your hand. We'll give you another minute or so to raise your hand if you want to make a public comment. All right. Crispy, you are most reliable. I think you've been with us from our very first meeting. It is good to hear from you and appreciate your time. You have 3 minutes for public comment.
Thank you so much. So I'll be reading some comments from people who are incarcerated. And but before I do that, Crispy, survivor of harm, actually one of the harms that I have experienced was from a person who was under the influence. Was a hit and run victim. So this is a very interesting discussion. So Dortel Williams, incarcerated at Chickasaw Valley State Prison, 12 seconds. Well, that's how long it takes, sorry. On this topic, with public safety being the primary goal, I wonder if mandating breathalyzers at the expense of the person offending in this area would be an effective safeguard. And that was discussed. So I'll fill him in on that. Eric Phillips from San Quentin Rehabilitation Center. I think the BAC should go down to 0.05%. With this, it would be a good thing to send first-time DUIs to mandatory counseling where participation is expected. Drug and alcohol addiction is not the main problem, but a major symptom to past childhood and even adult trauma. So it's important for the offender to know what part of his past triggered the addiction. And from Jasper Stallings, incarcerated at Valley State Prison. Good morning, panel. Hi, I'm Jasper. I wanted to share a few words regarding the current discussion on drinking and driving under the influence and introduce the benefits of more local substance use disorders or SUD centers that can be very instrumental and beneficial to our local communities. I know you can create policy after policy that can ultimately prevent a substance user from getting behind the wheel. And yes, lowering the back to 0.05 is a good start. Of course, that will help. However, if we as a society want to see a safer road, we must search for more creative ways to solve this problem and possibly use a more holistic approach and utilize scientifically proven methods to help someone through their recovery. As a peer support specialist, I would want nothing more than to see more investment in SUD centers that incorporate mindfulness practices in its treatment plans. So everyone in a vehicle in California, especially, can be fully present behind the wheel and establish more penalties if someone is caught under influence. More fees can go into SUD centers. That's just my opinion. Thank you. And from Ralph Taylor, he's incarcerated at California Substance Abuse Treatment Facility. I consistently advocate for consideration as well as implementation of progressive-oriented measures and our policies, reducing the need for prison construction or investment in prisons and associated extremist sentencing laws, tough on crime mentality, and prison incarceration over social, environmental, and restorative justice that necessarily entails rehabilitating people in accordance with their humanity and a human world where we all in a human world where all life is social. And that's all I have. And I thank you for all the hard work that you guys do.
Crispy, thank you so much. Thank you especially for being a conduit to folks inside. It's super valuable to us, and please extend our appreciation that people are paying attention. Thank you to staff again for another terrific meeting today. Thank you to my committee members, Assembly Member Brian, all of our witnesses. We will be in touch and have a good afternoon. This brings the meeting to a close. Thank you all.